It is 12 o'clock on Tuesday, March the 7th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Campbell, Davis, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders? I will take a moment of personal orders here, or privilege, whatever you want to call it. The Giles County High School Bobcats were victorious over Union City last night, and they are going back to the state tournament, whatever you want to call it, in Murfreesboro. First time since 2012, I believe. So they have worked really, really hard. We're very proud of them. Anyone else? We go to our Sergeant of Arms, Mr. Trotter, to bring us our words of wisdom for the day.
Go, Bobby. Stay prayed up.
I put him on the spot. He didn't know our customary procedures here. But very good. All right, members, we've got a lengthy calendar, but we're going to take care of a few things before we begin today. Item number 1, House Bill 1029 by Representative Littleton will be rolled 1 week. Item number 2, House Bill 1030 by myself, rolled 1 week. Item number 14, House Bill 1242 by Representative Powers, roll 1 week. Item number 15, House Bill 1248 by Representative Powers, rolled 1 week. House Bill 248 by Representative McCalman, roll 1 week. House Bill 415 by Representative Davis, roll 1 week. House Bill 510 by Representative Reedy, off notice. House Bill 941 by Representative Alexander, roll 2 weeks. House Bill 841 by Representative Lynn, roll 1 week. House Bill 1090 by Representative Lynn, roll 1 week. Members, if you will, turn with me to item number 8. Item number 8, House Bill 794. Motion. By Chair Lady Hazelwood. You are recognized. There is an amendment code 4831. Do you wish to proceed with that amendment?
Motion.
The amendment does make the bill.
You're recognized on the amendment.
Thank you, and the amendment does make the bill.
Okay, we'll go ahead and attach the amendment. All those in favor say aye. Aye. Those opposed, the ayes prevail. You are now recognized on your bill as amended.
Thank you, Mr. Chairman. This bill has to do with the electronic monitoring indigency fund. And just to give some background for the committee, the EMIF fund was originally created to pay for the cost of ignition interlock devices for indigent Tennesseans. Over time, the scope of that fund was expanded to include non-ignition interlock devices, such as transdermal GPS and so forth. In 2019, the fund was bifurcated so that there's 2 accounts, one for interlock, one for non-interlock. And the assumption was that the interlock charges would pay for the other devices from the surplus. There's a small problem with that, as there has been no surplus. So there are no fees presently going into the non-interlock account. In fact, every year the budget has had to include additional non-recurring state funding to supplement the fund. So what this bill is attempting to do is to make that fund self-sustaining, as it was the original intent. So last year, this General Assembly passed legislation that created a task force to study over the summer and make recommendations on the future of the EMIF. And the bill that I bring to you today incorporates those recommendations from that task force. So among the recommendations were amending the definition of indigency, because one of the things that we found that there was a wide variety of how indigency was applied across the state. Some courts, basically anybody that asked, evidently they got a check mark. Other courts did a more thorough review. So we feel like there are people who are getting access to the fund as indigent when perhaps they really aren't. So we attempted in this bill to make some corrections to address that. We required any offender receiving assistance through the plan to pay a portion of the monthly fee, because we felt strongly on the task force that no matter what your financial condition, if you had the monies to get yourself into the situation, then you should have some money to at least address the situation in a whether that be a nominal amount or the full cost. So the maximum in this bill would be $30 that an indigent person would pay per month. Again, we just felt like the folks should have some skin in the game. We also recommend funding non-ignition interlock electronic monitoring devices through a grant program, because we are not convinced that there's going to be a surplus from this program to cover it as was originally thought and planned. So that would be set up and handled by the executive branch. So the amendment that we just put on the bill that makes the bill does not change who's required to get one of the devices. It doesn't change the maximum amount of $200 that could be required to pay. But it does require, as I said, the $30 minimum payment from anyone declared indigent. And it sets up a series of guidelines for the courts to consider when they're determining the indigency factor. So with that, Mr. Chairman, I would stand ready for questions.
Thank you for that explanation. Members, do you have any questions for the sponsor, Leader Lamberth?
Madam Chairman, I just want to say thank you for working on this issue. This has been out there for years, and there's no requirement on the state to even have an indigency fund. I mean, it is good that we have this. It's good that we partner with our locals. These are folks that can take advantage of technology that would otherwise be out there available to anybody, and I love what you said. I mean, you know, if you've got the money to get yourself into this kind of trouble and be charged with these type of offenses, then a minimal fee is extremely appropriate so that folks have a little skin in the game. This has been a long time coming, and so just thank you for working on this. There's many large issues you work on, obviously, as our Chairman of Finance. By the way, Chairman Doggett, it didn't go unnoticed that you pulled the Chairman of Finance up first. I'm not sure what budget amendment you're filing, but we all noticed that.
It's noted.
So, yeah. But this is a smaller issue to a lot of folks, but it makes a big difference out there, and it does allow this fund to be, I think, stretched out and really help a lot more people, because we don't have to do this, but since we're doing it, it was being, I think, kind of monopolized by a few individuals that were overusing it, and this spreads it out so everybody can use it that needs it. So thank you for carrying this bill, and I very much support it.
And I would say, as Chairman of Finance, it's cost the state a couple of $1 million, some years more than that, and only in state government would we view $2 million as sort of inconsequential. But it really isn't. $2 million is still $2 million that the state could apply somewhere else. So thank you, Leader.
Thank you. Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. Chair Lady, you know I love all your bills, okay? All of them.
Until after the budget's passed, right?
Until after the budget is passed. Then I have a critical eye. But thank you for this one. What I'm not clear about is what the consequences are if you have an indigent person that starts and then fails to keep up payments. What kicks in at that point?
I believe that there would be a revocation of the device if the payment isn't made, and the consequences of not having that device would apply.
Do you have numbers from your fiscal memo that would indicate what our savings are in having the device and the $30 buy-in versus having an indigent person sitting in a facility with no work and we paying room and board, we being the state and the taxpayers?
The fiscal note on the bill shows an increase in state revenue from the $30 that we would be collecting from the indigent, but it also increases state expenditures, so the fiscal note is a wash.
But does that give consideration that we're saving money? So it's really a net positive for the state, isn't it?
The fiscal note just looks at this bill in its current form, which would be the $30 per person. And frankly, Representative Hardaway, I would think it would be worth someone's $30 per month. And most of us, you know, we find ways to pay for the things that are really important to us. So I don't really think that there's anybody in the state who would be in this position that couldn't come up with the $30 per month to keep the device and to keep themselves out of a jail situation.
Okay. Thank you, Madam Chair. I'm looking forward to having some off-grid conversation with you. There's some people who are not budgeting and may or may not have the $30, and they may need some assistance in the budgeting aspect of it also.
Well, let me make it clear. First of all, the issue is the judge is going to have the latitude at the end of the day to whether to declare indigency or not. But I think it's just as important for the dignity of a person to be able to contribute for anything that they do. And so I think that $30 is not an unreasonable amount. We kicked around a lot of different ideas about the number, but $30 is where the committee came down on, but I'd be happy to have offline conversations with you about it.
Thank you, Madam Chair. Madam Finance Committee Chair. Thank you, Mr. Chairman.
No, thank you. Any other questions for our sponsor? Seeing none, we're now ready to vote to send House Bill 794 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on to full criminal. Members, let's go to item number 3. Our calendar is beginning to shrink even more. Item number 3, House Bill 717 by Representative Sparks is rolled 1 week. Item number 17, House Bill 720 by Representative Sparks, roll 1 week. Members, let's go to item number 9, House Bill 1253 by Representative Crawford. Motion. You are recognized. There's an amendment code 4959. You wish to be recognized on that amendment? Yes. All right. Motion. You are recognized on the amendment.
Thank you, sir. Good afternoon, committee. Bill does is fix a problem that we have in our system now. Under current law, witnesses for the state who is necessary for trials that live more than 5 miles away are to be, they can receive funds, you know, to offset their expenses. Last session, we passed House Bill 2165 to make an ultimate goal that we would be able to fix the problem that we were having, and witnesses would receive that funding in a timely manner. The reimbursement statute is TCA 4025-129, and this gives the authority to the Department of Corrections to be able to pay those expenses. There's still been some confusion on about getting them paid either beforehand or afterhand. It's not been in a timely manner. So that's what this bill fixes. We're going to go in there, and in that first TCA 4025-129, we're removing the word immediately, and we're changing the word may to shall. So we can get the witnesses' expenses paid in a timely manner and keep our court system running proficiently. That's what this amendment and bill does, and I'd ask for your support. Ready to answer any questions.
Thank you. Does the amendment make the bill?
Yes.
All right. Any questions on the amendment? Seeing none, we're voting to add amendment code 4959 on the House Bill 1253. All those in favor say aye. Aye. Those opposed, the ayes prevail. We're on 1253 as amended. We do have testimony here, so without objection, we will go out of session. to hear from Mr. Jared Effler, District Attorney General for the 8th Judicial District. Where would you like me, Mr. Chairman? You can stand at the podium, you can wherever you want to go. If you would, identify yourself for the record, and you'll have 3 minutes for your comments.
I will try to be very brief, Mr. Chairman. I'm Jared Effler. I have the privilege of serving as the elected district attorney for Tennessee's 8th Judicial District, and I also serve as the Victim Services Chair for the Tennessee District Attorney General's Conference. Unfortunately, there are numerous outstanding victim expense claims across our state, and we believe this legislation will improve the efficiency and effectiveness at which these claims are reimbursed to our victims, especially those victims of violent crimes and domestic violence. We have been working closely with the Tennessee Department of Corrections. They are in support of this legislation. However, it's very important to point out that this legislation does not hamper the Department of Corrections' ability to seek reimbursement for the expenses that they expend to witnesses in cases where the defendant is not indigent. So I want to be very clear to that. On that point, that was a concern for the Department of Corrections, and this bill does not hamper their ability to do that. Mr. Chairman, I'll be glad to entertain any questions you or the committee has.
Yes, sir. Thank you. Do we have any questions or comments for our guest? Representative Hardaway.
Thank you, Chairman, and good afternoon, General. Thank you for your service to the state and the people. When we're looking at the reimbursement aspect, help me understand, I support the bill, but what makes the Department of Corrections a better vehicle for handling the reimbursements?
For lack of a better explanation, that's the way it's always been since I've been prosecuting Mr. Hardaway. But they understand the importance of seeking reimbursement for our witnesses because, quite frankly, some of our witnesses are placed in a financial burden to attend court. And our witnesses and victims, when they attend court, they should not be faced with the choice of whether or not they need to sleep in their car in the Justice Center parking lot while they wait to appear in court the next day. No witness or victim should ever be faced with that dilemma. And by streamlining the efficiency and effectiveness of victim reimbursement, that we hope to eliminate those concerns.
And on occasions where the witness would not have the funds in their pocket, can the Department of Corrections advance the funds or pay for the services?
Absolutely, and that's where we work closely with the Department of Corrections. We try to get those requests for advancements to the Department of Corrections within 30 days of our trial date so that we can get the money in the pocket of those witnesses who will be coming to court, and they will not have to suffer a financial burden to help the state of Tennessee prosecute our cases.
All right. And in the cases where you have to do relocation of witnesses, are these funds for those individuals also, or is that something separate?
That's an entirely separate issue, Mr.
Okay.
Hardaway.
All right. Thank you. Thank you, Chairman.
Yes, sir. Thank you. Representative Towns.
Mr. Chairman, thank you. And thank you for the bill as well, Chairman Crawford. Now, as it relates to those that need this advancement, are we communicating this throughout so people will know that in the event that some of this nature happens, that they can get the money they need so they come in and help us complete the process of prosecuting people that are violating the law?
Representative Towns, that's a task that falls primarily upon our victim witness coordinators across our great state who I believe do God's work each and every day to make sure that our victims get what they need to come to court. And that is information that is shared with them, and then our victim witness coordinators in turn file those claims with the Department of Corrections. Then that money is funneled back into the pockets of those victims so they can get to court.
Okay. Now, secondly, will we kind of monitor this and make sure that we are doing enough? Because if not doing enough, they're still sitting in the parking lot or can't eat or can't get there.
Well, and I think this bill is a reflection of us making sure we are doing enough because we're hearing from victims across the state that there's many outstanding claims, and we believe that this bill will provide a statutory fix for that.
Okay. Thank you, sir.
Thank you. Any other questions for our guest? Seeing none, thank you for being here and for your testimony today. We're going to go back into session. Representative Crawford, you recognized.
Thank you. Committee, this will make us run more efficiently. This will help the people that need help, and this will also get bad people off the streets. So I ask for
Question
your
on the bill.
support.
Thank you for that. Question's been called. Any objection? Seeing none, we're voting to send House Bill 1253 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Chairman and Committee.
All right, let's work our way back to item number 4. House Bill 253 by Representative Parkinson. You're recognized.
Thank you, Mr. Chair, and thank you so much to the committee. Let me just give you a little background real quick. I want to read a story. This young lady, her name is Lori Delancey. Lori Delancey is a Nashville businesswoman. She enjoyed watching ancestry shows such as Finding Your Roots and Who Do You Think You Are with her husband and stepchildren as a family. As a family, they took home DNA tests hoping to learn more about their family history, but the tests ultimately revealed that her husband's eldest child was not biologically related to him. The deception was a dagger to the entire family unit, as her husband, Scott, had been a loving provider to the child for over 12 years. Their subsequent paternity fraud resulted in complete relief from future child support, but it also meant the loss of a child. She was a sister, a niece, and cousin. The emotional loss combined with the financial ramifications was extremely stressful. Plus, there was the constant knowledge that they were deceived for over a decade. Paternity fraud is a real issue nationally. The issue affects parents and children alike. Paternity fraud is a violation of a child's right to know his or her own identity and the identity of his or her father. The child has a right to have a relationship with his or her biological father and mother. Additionally, the proper identification of a child is important for genetic and medical reasons, as well as inheritance and medical insurance coverage. House Bill 253 creates a misdemeanor for anyone who intentionally and knowingly seeks to establish someone as the biological parent of a child when they knew or reasonably knew that the person is not the biological parent of the child. It creates a misdemeanor for persons who tries to be established as a biological parent, but reasonably knows or should know that they are not the child's biological parent. And with that, Mr. Chairman and committee, I'm open for any questions.
Thank you for that explanation. Members, are there any questions for the sponsor? Chairman Holsey.
Thank you. And sponsor, what if the mother doesn't know? How do you prove for this misdemeanor to stick that she knew and hid it and it was not disclosed? How do you go about proving that?
Yes. Okay. Thank you, Mr. Chair. I got the nod. And that's why we put the threshold so high. She had to have known or reasonably known. That was our purpose for putting that threshold high. If she didn't know, it doesn't affect her.
Thank you, Representative Johnson.
Thank you, Mr. Chair. And I guess the same question, but how do you prove that she didn't know?
Thank you, Mr. Chair. I think you have to prove that she did know, not prove that she didn't know.
That being said, what ways do you think that will happen? Proving that she did know.
Thank you, Mr. Chair. Do I need to look at you, Mr. Chair, or just go ahead and answer? Okay, thank you. I'm just trying to be respectful of the committee. I think that's something that's worked out in the courts, with witnesses and whatever. I'm not an attorney, and I didn't get a chance to sleep at the Holiday Inn last night either. And so, but I think that's something to be worked out in the courts. But that's why we put the threshold, like that, because they have to prove that she did know and that she did intentionally, try to deceive for the purpose of taking property from that other individual. It's a pretty high threshold.
Any follow-up? Okay. Representative Hardaway.
Thank you, Chairman. I've worked on issues of fraud when it comes to paternity since before I got here with Representative Catherine Bowers, as a matter of fact, and Representative John DeBerry. So I'm certainly sensitive to it, but I have an aversion to having criminal charges pending against a parent when it's involving a custody issue. And I believe that that's why we're in civil court on these matters in the first place, and that as long as we have the ability for the judge to make the leeway to make decisions on how to address these situations, that we should leave it there. So I have a problem in moving from that position to criminally prosecuting a mother about the parentage of her child.
Thank you, Mr. Chair, and thank you, Representative Hardaway, and I completely understand that. But I also understand in looking at these stories, like the story of Lori Delancey, it's criminal what they had to go through. It's criminal that her family was destroyed. It's criminal that so much money was taken out of her family's household because someone decided not to be honest and truthful on the front end. That's criminal. It's criminal that a child can die because he was not able to receive the medical treatment or a donation of a lung that he may have needed because he was a medical match with his actual biological father, but the person listed on his biological father was not his biological father. It's criminal that a child whose biological father passes and leaves an inheritance cannot receive that inheritance because someone was not honest on the front end. What this bill is simply trying to do is, I hope that no one gets that no one receives a misdemeanor for this, but I do certainly hope that this serves as a psychological deterrent for us to be honest on the front end so that families aren't destroyed on the back end. And so that's what the purpose of this legislation is. But I completely understand, your point. I promise I do. But we have to do something because in the position that we're in, the feds incentivize almost anyone signing on a voluntary acknowledgement of paternity. And it allows for, in some cases, and keep in mind now, and remember, two things. One is, and y'all just follow my ADHD mind, if you will. One is 1/3 of the names listed on birth certificates nationally, 1/3 of them are not the actual biological fathers. So we got a problem. Right? And there are no ways for us other than this to correct this problem on the front end because we tried running legislation to ensure that DNA tests are done on the front end, but the feds blocked that because of the Fed policy. So I don't want to criminalize anyone, but I do want to make sure that these children have a right to their biological father, and that father has a right to his child. Because the way we're going right now, that's 1/3 of the children that are listed on birth certificates, their father may have missed an opportunity watching their children grow up. And that's unfair to that father. And the only person that knows the truth is the mother. So how do we ensure that the truth is given on the front end, so that that father does not miss an opportunity raising his child, or that child does not miss an opportunity being around his father?
Thank you for that. Some of that I agree with, some of it I don't. VAP, for instance, there's the incentivization that comes from the feds is more in line with identifying the paternity and putting that father on child support. That's where the feds are more focused on incentivizing the paternity issue. And I just believe that when it comes to medical and inheritance issues, that there's going to be some that fall through the crack. There are now. There are people who sometimes are never found, that the heritage might be identified. So, and I'm just having a difficult time, as I said initially, making that quantum leap from civil to criminal actions involving custody and parentage. And I can't see justifying locking up the mother of a child and the child at some point thinking that it's because of the child, and in spite of the fact that it's because of the fraud. I just think that puts things in a perspective that's damaging to the psyche of the child, and it's certainly stressful on the relationships that have been formed up to then. And I know all the arguments, and as I said, I've put quite a few of them forth, but I just can't get to that. This is criminal, and there will be criminal charges brought against a mother. So, thank you.
Thank you.
Representative Howell.
Thank you, Mr. Chairman. I think I missed it. You mentioned that this creates a criminal charge of misdemeanor, but what class? What class would it be?
Class C misdemeanor, sir.
Class C?
Yes, sir.
Which is?
Lowest.
The lowest one,
Yes,
30
sir.
days fine, $50
Yes, sir.
fine. Okay, thank you.
Yes, sir.
I believe it's actually a Class A misdemeanor.
Is it Class A?
It is a Class A, yes, sir.
Okay, well, let me roll this bill 1 week so I can get it to where I want it, because my intent was the lowest misdemeanor.
Okay. That objection, we're going
Thank
to roll House Bill 253 1 week.
Did you have a question?
Let's go to item number 12. Item number 12, House Bill 1193 by Representative Williams. You're recognized.
Thank you, Chairman and members. House Bill 1193 was brought to me by the Jewish Federation of Tennessee. This bill would increase the criminal penalty for knowingly or recklessly desecrating a house of worship. As the body may know, we've spent several hundreds of thousands of dollars helping our places of worship, with dollars helping secure them over the past several years. And what's happened is that they have, in some instances, caught someone who was getting ready to vandalize a place of worship, and then because they didn't do it, they couldn't charge them with the crime. This would allow someone to be charged with a crime who was knowingly do that, someone who was caught on the premises with paint cans or whatever as it relates to that. And so I'm happy to answer any of the questions that the members might have. This was brought to me by the Jewish Federation that represents the big 5 communities in our state. Happy to take any questions.
All right, previous question's been called. Any objection? Seeing none, we're voting to send House Bill 1193 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Item 13, House Bill 1198 by Representative Williams. You are recognized.
Thank you, Chairman and members. Just as a matter of discussion regarding House Bill 1198, this bill is named after what would have been a constituent of mine, Silas Gable Flatt. Silas's family was traveling from Livingston to Cookville, and in Rickman was hit head-on by a fourth offense DUI person whose parent had, in this instance, and a loved one in a previous instance, in their third DUI, a parent had given their vehicle without interlock or insurance or without a license to drive their vehicle, and this person chose to drive intoxicated across my community. In the process of doing so, when he hit the Flatt family head on, this expectant mother whose son was expected to be born by C-section in Bandy 2 days later was killed. What this bill would do, it would simply say, much like other laws in the state, that someone who knowingly, who provides their vehicle to someone who knowingly is intoxicated or inebriated, that person themselves would be charged with an accessory. This bill would establish an offense of doing so, and that the first offense would be, for that person, would be 48 hours of incarceration. The second offense would be 72 hours. And for the third offense, or any offense after that, it would be 7 days. The goal here, as many of you know in criminal, I don't find myself in this committee very often, but as many of you know, in most instances, the people who know more about law enforcement or adjudication of law are people who break the law repeatedly. And in this instance, they know that they can drive someone else's car and their parent or loved one or whoever enabled them to do so won't be penalized. This bill seeks to change that. I'm happy to answer any of the questions that you might have. I will say, as a matter of thanks, legal counsel, Ms. Fogarty, was fantastic over the summer when this happened. She worked with me regarding this tragedy. And so this was the solution we came up. Is it perfect? No way. There is no such thing. But it is a good first start, I think, into representing this people group, really, who should be at home with their loved ones instead of not with us. So happy to answer any questions members might have.
Thank you for that. Representative Towns.
Mr. Chairman, thank you. And thanks for the bill as well. It's horrifying to think of a situation like that. I mean, I'm pretty sure it happens across the country every day. Mm-hmm. Now, my question becomes is that, what happens if you got a kid or a nephew or someone in the family, they steal a car? You know, kids steal cars from their parents and so forth. What happens then?
Thank you, Chairman. In this instance, what it would do is facilitate a parent or a loved one to actually report the car stolen. You know, a lot of times what would happen is, oh, wait, little Johnny was in an accident and killed somebody. Oh, by the way, he stole the car. And they could still do that now. The difference here would be the moment they know the car was stolen and they didn't have permission, then it's their job to notify law enforcement so that they aren't charged with this crime.
So is it spelled out that way where they would know, well, I mean, you know, a lot of times it could be overnight. These jokers steal your car, you're in the bed, getting ready for work the next morning. These little sapsuckers out somewhere having a joyride end up doing the same thing, hitting somebody, maiming somebody. You don't know until the next day, possibly.
Exactly, but I'm sorry, Chairman. In this instance, it is the person's job or role to report it as soon as they know. And I'm certain that we had District Attorney Effler was here earlier. I'm certain whether it's him or District Attorney Dunaway, General Dunaway from my district, they would take those things into consideration as it relates to that. If 3 days go by and they didn't report their car stolen, then there probably would be a problem. But if we're able to say, listen, I was sleeping in the middle of the night, I didn't realize that I got up and got out of the shower the next morning, I am certain that the district attorney would take that into consideration.
Well, finally, and I would hope so. That's what we would want. But finally, you got some of these kids because our society is so undisciplined. In other words, what I mean is that they didn't get their butts whipped like we got our butts whipped. And some of these parents are intimidated by their children. I come up in an era where the old folk tell you, I brought your butt in this world, and I will take you out if you get out of line. But you have some people, they are afraid of their children. They're afraid of their children. Unfortunately, they're afraid of their children, okay? So I would hope that on the record that, a lot of the family business comes out when certain things happen, that we would make allowances for stuff of that nature too. Some of these kids, because of all this old crazy food we feed them, they're biggest houses, okay, at 13 years old, 14 years old. And you see what they're doing with the advent of them having access to guns, stealing guns out of cars, going out and carjacking and doing all the crazy stuff we would never think about. But that is taken into consideration too. I want the parents to be accountable, or whoever owns the car to be accountable for sure. But I don't want us to overreach and we penalize the parents when it shouldn't be. But I know something has to be done. With drinking and driving and all this crazy stuff that's happened because it's deadly. It's absolutely deadly. Mm-hmm. It's a problem. So thank you for the bill.
Thank you, sir.
Thank you for that. Representative Russell.
Thank you. My question's been answered. Thanks.
Okay. Any other questions for the sponsor, Representative Hardaway?
Thank you, Chairman, and thank you, sponsor, for the bill. I certainly support it. I had a bit of curiosity as to whether another incentive might be that if they don't report that car stolen, or if they allow the driver who already is banned, legally banned from driving without the equipment, if they allow that, it's quite possible that insurance wouldn't pay off because it's a knowingly they're participating in criminal activity. I don't know that, but I'm sure somebody on our committee knows, or you might be aware of that. But that should certainly incentivize folks to do the right thing.
I don't know what the answer is entirely, Representative. I do know that in most cases, when you have vehicle accidents regarding claims, the uninsured motorist or the driver who's uninsured ends up not paying a dime, and the insurer who was hit, their insurance company sues. The other driver, in this instance, would be the parent of the other driver because they did it, but it's all based upon the claim of the damage to the vehicle and not necessarily a criminal penalty. That would have to be brought by the district attorney or law enforcement.
Right, but then my point was that having that criminal charge involved in the proceedings might force the insured to have to pay it out of their own pocket.
Right.
Okay? So I think you've done a good thing here.
Thank you.
All right.
Appreciate it.
Thank you. Thank you, Chairman.
Yes, sir. Thank you. Any other questions for our sponsor? Seeing none, we're now voting to send House Bill 1198 on the full criminal. All those in favor say aye. Those opposed, the ayes prevail. You move on. Thank you.
Thank you, Chairman, members.
All right. I accidentally skipped a couple members here, so we're going to go back. Item number 10, House Bill 612. Representative Hawk.
Motion.
You are recognized.
Thank you, Chairman, members. House Bill 612 clarifies a provision that was recently added to the Tennessee Code through last year's Public Chapter 399, where we changed the legal definition of intellectual disability for the purposes of capital punishment. What this bill does is state that the AOC is responsible for payment of determination of whether a defendant is intellectually disabled or not under TCA.
Thank you for that explanation. Any questions for our sponsor? Representative Hardaway.
Okay, could you repeat that summary, please?
We passed a bill in 2021 saying that someone on death row could have a challenge if they had not previously been determined to be intellectually disabled or not. We passed that bill last year. What we did not pass last year was a mechanism that said the Administrative Office of Courts could and would pay for this determination of intellectual disability. So we passed the law last year, and the AOC has come back this year with clarifying language that says they'll pay for this study.
For the service to be done. All right, good bill, and thank you for bringing it. Love working with you.
Thank you.
All right, thank you, Chairman.
Thank you. Any other questions for the sponsor? Thank you. Question's been called. Without objection, we're now voting to send House Bill 612 on the full criminal. Those in favor say aye. Those opposed, the ayes prevail. You move on.
Thank you, Chairman, members.
Thank you. Item number 11, House Bill 285 by Representative Whitson. You are recognized.
Thank you, Mr. Chairman. And I don't mind following Representative Williams. He's a good man to be behind all the time. So thank you very much. Members, earlier this year, the Union County Sheriff and his deputies raided a cockfighting derby, citing 98 individuals of crimes relating to cockfighting while preventing more fights that had been planned throughout the day at the major clandestine derby. It's been reported upwards to $100,000 is being exchanged in these cockfights that happen usually every other weekend, with winners at times taking over $20,000. Cockfighting is both a major animal welfare concern and a doorway to other illicit, criminal, and black market activities. It is closely linked to many social pathologies, including money laundering, illegal drug use, gambling, addiction, violence, tax evasion, and gang activity. Gambling is the norm at cockfightings and the primary reason for the fight to occur. Thousands of dollars can exchange hands as spectators and animal owners wager on the fate of the birds. Because of the large sums of money involved, cockfight derbies often attract hundreds of people engaging in a range of criminal activity, which creates a dangerous situation for law enforcement and residents of the local community. Excuse me. Unlike legalized gambling or the state lottery, the government cannot monitor and collect income taxes from gambling or illegal cockfighting. Cockfighting also drives outbreaks of serious domestic poultry diseases such as the highly contagious Newcastle disease and the bird flu virus. 10 of the 15 bird flu outbreaks in the U.S. originated from illegal smuggled fowl for cockfighting. The current outbreak of highly contagious bird flu viruses has resulted in the mass killing of 60 million birds, mainly laying hens. That extraordinary loss of life has driven a surge in egg prices from a dozen eggs to run up to about $7.50 a dozen in Tennessee. Cockfighting birds can play a role in extending the range, duration, and the outbreak of the disease. Currently, it is a Class E felony for any person in the state to own, possess, keep, use, or train any bull, bear, dog, swine, or other animal for the purpose of fighting, baiting, or injuring another animal for amusement, sport, or financial gain. The exception is for fighting cocks. Tennessee is one of just 8 states without felony-level penalties for the crime by treating cockfighting as a Class A misdemeanor. House Bill 285 will make a Class E felony the lowest level felony to own, possess, keep, or use or train any cock for fighting, baiting, or injuring another animal for amusement, sport, or gain. Cause for amusement, sport, or gain any animal to fight, bait, or injure another animal, or permit any cockfighting activities to be done on any premises under the person's charge or control or aid, or to assist, encourage, instigate, or support with criminal intent in attempting to carry out these criminal acts. Also, House Bill 285 will make it a minimum Class A misdemeanor fine of $1,000 for knowingly to be present as a spectator at any place or building where preparations are being made for cockfighting, or knowingly cause a person under 18 years of age to attend a cockfight. With that, Mr. Chairman, I renew my motion.
Thank you for that. Are there any questions for the sponsor on the bill? Chairman Hulsey.
Thank you, Mr. Chairman. In preparation with their bill, has there been an increase, do you know, in the last 10 years of cockfighting that there's been an increase in arrests? And there's a reason why I asked that. If this is an increasing thing, or is it slowly dying out?
Chairman Hulsey, I cannot answer that. I just know the number of arrests have occurred all across the state and the United States. It seems to be an international connection to this event, And just like I said, just earlier this year, Union County had 98 people attending a cockfight.
I think you're exactly right about the motive is gambling. I almost wish you'd run a bill that enhances the penalty for gambling at a cockfight, and that would disperse the rest of it, I would think.
I don't think you would have a cockfight if gambling was not involved.
I agree.
Any other questions for the sponsor? Seeing none, we're now ready to vote to send House Bill 285 on to full criminal. All those in favor say aye. Aye. Those opposed? No. Noes prevail. The bill fails.
Thank you, Mr. Chairman and committee.
If you wish to be recorded as a yes, please see the clerk. Item number 16, House Bill 587 by Representative Gant. Motion. You're recognized.
Thank you, Mr. Chairman and committee. And Chairman, let me first tell you thank you for your support of this and many of the members that have signed on to this piece of legislation that's dear to my heart and important to not only me, but a lot of Tennesseans that are out driving on our roadways, whether it be our family members or relatives or whoever. This piece of legislation applies to them as well. This affects our DUI laws that we currently have here in the state of Tennessee, and also I wanted to thank former DA Mike Donovan for his support and leadership on this initiative, as well as a great ambassador for this cause as well. Currently it is an offense to operate a motor vehicle if the blood alcohol concentration level is a 0.08% or more. Upon conviction for a first offense, an individual must be sentenced to at least 2 consecutive days in the county jail and no more than 11 months and 29 days. Anyone convicted of a DUI for the first time with a BAC of 0.20 or more must be sentenced to at least 7 consecutive days rather than at least 2 days in the county jail. The proposed legislation that is before you revises the minimum BAC for these enhancement purposes from the current 0.20 down to a 0.15. This means that DUI offenders whose BAC level is between 0.15% and 0.19% will now be subject to the enhanced penalties of 7 days in jail. And I believe that the gap between the presumptive impairment of a 0.08 and the elevated dangerousness of a 0.20 high BAC threshold is too great and needs to be addressed by lowering the high BAC level to a 0.16 or a 0.15 for the enhanced 7-day mandatory minimum sentence. This reduction of the high BAC threshold would capture more impaired drivers who are at or near a BAC level that is twice the legal limit. This would also compel more guilty pleas to the DUI first offense and would have the punitive and deterrent effect that would promote greater highway safety. Since this legislative proposal would only affect misdemeanor sentencing, there would not be any anticipated physical costs to the Department of Corrections. And I believe that the district attorneys here and law enforcement are very supportive of this legislation. Mr. Chairman, I could go on, and I know the committee's got more bills to hear, and I will turn this back to you for any questions.
Thank you for that explanation. Are there any questions for the sponsor? Chairman Holsey.
It's not a question, it's a comment. You very well may be onto something. I can remember a long time ago, people who blew a .25, .28, .3. They're driving 25 mile an hour under the speed limit and actually are less danger to people than somebody who blows a .16 to a .19 and don't understand that they're impaired. So that you're probably on the right track.
Any other questions, comments? Seeing none, we're now voting to send House Bill 587 on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You move on.
Thank you, Chairman and committee.
You're a little late there, Leader. We're going back to item number 5, House Bill 1475 by Chairman Halsey.
Second.
You recognize there's an amendment code 4976. You wish to proceed?
4976, that's correct.
Yes, sir. All right, you're recognized on the amendment.
The amendment just adds a sentence if you want to put it on the bill, and I'll explain the bill.
All right. Without objection, we're voting to attach amendment code 4976 on the House Bill 1475. All those in favor say aye. Aye. Those opposed, the ayes prevail. We're on 1475 as amended.
Thank you, Mr. Chairman. My old department and some officers in my end of the state have brought this bill actually to me about an increased, it seems, cases where when police try to pull somebody over, they elude or run from the stop. Doesn't mean that they haven't always done that. It's been going on for years. It just seems to be getting worse. So this bill actually adds the minimum period of incarceration for both of these. If you run from the police and you don't endanger anybody, it's a Class E felony. If you run from the police and you endanger people while you're doing it, it's a Class D felony. So on a Class E, the minimum period of incarceration increases from 30 days to 90 days. And on the Class D, it increases from 60 days to 120 days of minimum incarceration. That's what the bill does.
Thank you for that. Any questions, Representative Gillespie?
Thank you, Mr. Chairman. And Chairman Halsey, thank you so much. Definitely support this. So 100% help the situation that I have going on in my neck of the woods. But would this be for both vehicle and foot evasion, or would it be for one or the other?
No, it's just for vehicle.
Just for vehicle. Thank you.
Representative Johnson.
Thank you, Mr. Chair. Does this bill remove the defense that the arrest was unlawful?
No, it does not. That sentence puts that in that was added on the amendment.
Thank you.
Any other questions? Representative Hardaway.
Thank you, Chairman. I just want to make sure of how that plays out for an unlawful arrest. If you are attempting to evade and prevent that unlawful arrest, then the charge of evading arrest could not be brought, or the unlawful arrest would be a defense. Which one are we talking about here?
It could be a defense, yes.
But the charge could still be brought even if it was an unlawful arrest.
I'm sure it would be, but the judge could accept that defense. I mean, it would probably have to be proven, but he's got the ability to do it.
Okay, but it's your intent that if it's an unlawful arrest, that you don't want the prosecution, or you just don't want or you just want it to be a defense. I'm okay with the bill if the unlawful arrest, if you can go to court and say, hey, and it's determined by the court to be an unlawful arrest, and that's what you were trying to avoid, that you would not be prosecuted for the unlawful arrest. Excuse me, for evading arrest.
Well, I don't know about that you wouldn't be prosecuted. That you'd have to show why you have a defense for an unlawful arrest. But you do have that ability under this law, so you ought to like my bill.
I like it a little better, but I'm trying to get there, Chairman. Let me mull it over, or Chairman Doggett, maybe the legal would want to weigh in.
Well, without objection, we'll go out of session and hear from Legal Services.
Michelle Fogarty, Legal Services. The bill as amended makes no changes to current law in that regard. So it would still be a defense to prosecution if the attempted arrest was unlawful. So as amended, the bill does not make any changes to the current law in that regard.
So it merely, the bill in its amended form merely increases the penalties.
That's correct.
Okay. All right. Thank you, ma'am. Thank you, Chairman.
Any other questions for Legal Services while we're out? Back in session. Leader Lamberth.
As my friend from Shelby County mulls it over, it didn't take me very long to get there on this one. It's extremely dangerous to evade arrest from an officer and to wreak havoc on our streets and amongst our communities. Mr. Chairman, I'm certainly with you, and I hope everybody else is too, because there is no reason whatsoever in a vehicle to evade arrest from officers. If it is an unlawful arrest, then that is something that should be taken up with a judge in a court of law in a setting where everybody is safe, not at 100 mile an hour going down the roadway. Literally endangering everybody else. It's just not a situation that it's going to turn out well for anybody. It endangers both the individual's life and everyone else around them. So, again, we're talking about increasing mandatory minimums. We're not talking about changing any other criteria. So, Mr. Chairman, fully support your bill and appreciate you bringing it.
Representative Johnson.
Thank you, Mr. Chair. I think, I've got to be honest. There are some people that a lot of times getting pulled over, they don't feel safe. And there's a reason for that, and we see it all the time. And so even though the intent of the bill I support, but I also understand that there are certain people in our community that don't feel safe when being pulled over, and with good reason. It hasn't ended well for them when they did nothing wrong. And so that is a concern I have with this legislation.
Representative Hardaway.
Thank you, Chairman. And I have to make this point on behalf of my community. Most of the folks that look like me have all kind of high blood pressure when we see blue lights behind us, because we don't know whether we're getting a good cop, bad cop. And we know that if we get a bad cop, that our lives, not just our health and well-being, but our very lives are at risk. So, and there are certain communities where we know who the bad cops are. And you're going to have individuals who have to make a split-second decision on whether they want to put their lives at risk or put the lives of those in the community at risk by running or trying to evade arrest. And I can understand that. That doesn't mean that I agree with all of it, but I can understand that. So I'm going to ask my colleagues to be sensitive to that fact, that we have folks who, because of systemic discrimination in law enforcement, where there are bad cops that still needed to be weeded out. And I want to emphasize 99.9% of our law enforcement officers are there for the right reason and doing the job the right way. I have family, I have friends, close friends in law enforcement, so I certainly support them and do what I can to try to make their jobs safer. But I just want to make sure that we understand that folks that look like me and look like Representative Joe Towns quite often feel we're at risk for bodily harm. That means getting beat to death or getting shot merely on the pretense of a traffic stop or some other reason. So I want to get that out there. Thank you, Mr. Chairman.
Previous question's been called. Any objection? Seeing none, we're voting to send House Bill 1475 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on. Item number 6, House Bill 1482 by Chairman Hulsey.
Thank you, Mr. Chairman. This deals with bail agents.
We'll need a motion and a second, please.
Motion.
You're recognized. There's an amendment code 4978.
That is correct.
Need a motion and a second on that amendment. All right, you're recognized on the amendment.
Thank you, Mr. Chairman. The amendment makes the bill. Bail agents are required to go to training every year, and there is a training cap set actually by code at $240, and that has not changed since 1996. So the agency is asking for the cap to increase to $450, but that amendment covers that, but an amendment also adds another section that they want bail agents to have a criminal history run at least once a year, and they have to pay for it, but that's the way it works. And every year they get a criminal history, and they get that by through the clerk of the county that they work in, because TBI can't run a criminal history for an association. And so this way it runs through the criminal clerk's office of the county they live in, and that's what the bill says.
Thank you. Any questions for the sponsor on the amendment? Seeing none, we're now voting to adopt Amendment Code 4978 on the House Bill 1482. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We're on House Bill 1482 as amended. Any questions for the sponsor? Seeing none, we're voting to send House Bill 1482 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on. Thank you, Mr. Chairman. Item number 7, House Bill 806. Going once, going twice. You'll need a motion and a second. All right, you're recognized.
Sorry, Mr. Chairman, I had the clerk had asked me to step out for just a moment, and one of my primary rules is never, ever, ever irritate the clerk in any situation. So for everybody here, both in the audience and the members, all our clerks should do a fantastic job, so just stepped out for just a second.
Maybe you should add to your rules, never irritate the chairman.
Mr. Chairman, I have violated that one daily and continue to violate it all the time. We'll put it up for consideration on the rules list, but it's just not there yet. I don't mean anything by it, but it happens. Sorry to be a couple minutes late there. So this bill deals with RICO offenses. I know we have some testimony on this, but Mr. Chairman, at its core, it is straightforward. There are organized crime activities that go on throughout this state, and they are prosecuted currently as one-off crimes. I mean, this crime, that crime, the other. The combination of those is what we're talking about with this bill. There are 69 different offenses that are listed in this particular bill, and I want to be crystal clear that it is not the intent of the General Assembly that isolated incidents of felony conduct be prosecuted under this part, but only as an interrelated pattern of criminal activity. That is specifically in this bill and will be a part of the law in this bill, so that you do not have a district attorney that would overcharge and just go after someone over a RICO offense that are conducting low-level criminal activity. This is to go after the worst of the worst. This is what's utilized on the federal level. This is what's utilized in other states. And if it were to pass here, this is what can be utilized in our state to go after the worst of the worst. So, Mr. Chairman, I know we have testimony, but that's what the bill does.
All right. Thank you for that explanation. Members, without objection, we're going to go out of session. Hear from Ben Rabin. Good afternoon. If you will introduce yourself. For the record, you'll have 3 minutes for testimony.
All right. Did I turn myself off or on just then? I hit a button.
Let's see.
All right,
If
very
you
good.
got a red light?
Yes, sir.
All right, you're good to go.
My name is Ben Rabin. I'm here on behalf of the Tennessee Association of Criminal Defense Lawyers. And we've all heard of RICO. When we think about RICO, we think about the mafia, the drug cartels, large organized crime associations. And the concern that the defense lawyers of Tennessee have is that this bill could encompass and does encompass, as written, a large number of other types of conduct that are not really what we imagine when we think of RICO, and subject people to enormous consequences of taking, in some cases, what could be Class C misdemeanors up to Class B felonies, starting at range 2, which means 12 to 20 years in prison at 45%, as well as civil asset forfeiture consequences as well. So when we talk about RICO punishments, it is extraordinarily high. First of all, this expands the definition of what constitutes a criminal enterprise, which is one of the requirements, to something that could be as small as an informal group of 3 or more people that just have a common name, colors, or symbols that has one of its primary activities to include one of over 60 specified activities. What do those specified activities include? Can include gambling, which is a Class C misdemeanor that could include a poker game. So if you've got a group of 3 or more people that have a weekly poker game and you give yourself a name like the Tuesday Poker Club, you do that more than twice, that becomes a pattern of racketeering activity, and it takes your Class C misdemeanor gambling club up to a Class B felony starting at 12 years, as well as civil asset forfeiture. What else is on there? Simple possession. If you have a group of college kids have a Tuesday afternoon sit around smoke marijuana group, that becomes from a Class A misdemeanor up to a Class B felony. Fake IDs is included. If you've got a fraternity at a college that's making a few fake IDs on a somewhat regular basis, that turns that from a misdemeanor up to a Class B felony. And what is prohibited? Having a pattern of conduct engaging that, but it's also included under this bill simply to receive proceeds from that activity. So if you've got somebody else who's engaging in that poker club, they give you $20 that came from that, you use that $20 to buy a shirt, you're now racketeering too, and that subjects you to a Class B felony and civil asset forfeiture. So we think that as written, notwithstanding the intent that's stated that I think makes sense, but the way that this is actually written and could be applied could encompass a number of relatively low-level activities. And I welcome any questions.
Thank you for that. Members, we have questions. Representative Towns.
Thank you, sir, for your testimony. What you just shared with us is that the bill itself would allow for everything that you just said to occur? Passed as it is?
Yes. Assuming that you have a group of 3 or more people that has some at least informal association where you have a common name or colors, and that is an activity that is part of that group. So if you just do it once, it doesn't necessarily count, but if you have a poker club and that's what you do and you have a name, and you do it more than twice, that would count.
Well, certainly, I see that as very dangerous to young people, especially college fraternities. I don't know, many of you all may or may not. I'm in a fraternity, okay, and we meet on a regular basis. You know, our kids are 18, 19, 20 years old. They play poker, they drink, they do certain things, and they always the coolest in the world, so they're going to give themselves names as just another. So this could be very damaging to our young college kids across the state that may get involved, whatever their groups are. And all of them, for the most part, got some kind of groups. It doesn't have to be fraternity. You got these other off-brand groups, which is a part of the college experience. And we're talking about they potentially wreck their lives with a felony, 12 to 20 years.
Yes, sir. And to be clear, these are things that are already illegal, but potentially as misdemeanors. And so it's not a matter, is it illegal or not to gamble, to smoke marijuana? It's, do we increase that up to Class B felony starting at 12 years? That's the question that this bill raises.
I don't like the way it smells right now because it's like a dragnet. Because if we just look at the college campuses, we'll run a lot of young people for the future, a ton of young people. Thank you for the testimony.
Thank you, Representative Johnson.
So thank you, Mr. Chairman. So this would also include, say, 3 guys on the football team wearing the same jersey, wearing their jerseys. And whether they buy a little bit of marijuana or gambling, they would fall under this as well.
Potentially. The standard is for that group is that one of its primary activities. And normally we think primary as the main, but when it says one of, potentially you could say, well, football is a primary activity, but if that group of 3 people that has the common colors, they say, well, we're going to smoke marijuana or make fake IDs, then I think that this could be construed to include that. Yes, ma'am.
Any other questions for our guest? Representative Hardaway.
Thank you, Chairman, and thank you to our guests for being here. So, do you have language that would make it a better bill?
Well, we currently have a RICO bill that's in place. So one language is what's already on the codes, and leave it like it is. I mean, if we wanted to improve it, I mean, we could require more people. We could remove some of these acts, some of the misdemeanors. We could require more instances of conduct, more serious types of conduct. There's currently language that requires what's called a meeting of the minds of the sort of collaborators, because this is basically a conspiracy bill. If you have lots of people doing stuff together, and part of what this is intended to do, if you had a gang and you have people that are committing horrible crimes of felony drugs and murder, and then you've got people who are in the gang but at the bottom that are maybe selling small amounts of marijuana, it allows you to get all of those people as part of the organization. And so, one way to narrow it could be to require kind of that meeting of the minds of the specific things that we're looking at, of murders and felony drug sales, that sort of thing, so that you're not also roping in, even if you have a gang, shouldn't be doing that, maybe selling small amounts of marijuana, but maybe those people don't know or not involved in the murders and the more serious things. Leaving that language in, I think, could improve it, that sort of meeting of the minds language. So I think there definitely are ways to enhance Tennessee's RICO statute, but tries to anticipate and eliminate some of these concerns of roping in the college kids, basically.
Okay, so I'm sure that I got what you covered. So a meeting of the minds requiring more people to be involved in the meeting of the minds. More activities in terms of the criminal activities, and looking at the list of offenses and actually having some of those eliminated, period.
Yes, I think that would help, and I would also be looking at the language about if you receive proceeds from the organization, where right now you don't have to be in the organization just to receive proceeds, and then spend that money on something else ties you into it. And there's also language that if you're, if you use that money to engage in the criminal conduct, that ties you in. I think that makes sense. That's what this should be. But you could potentially just receive money and use it for a completely innocent purpose without having engaged in the criminal activity. I think that is a concern of being potentially too broad.
All right. Thank you, sir. Thank you, Chairman.
Any other questions for our guest? Seeing none, thank you for being here with us today. We're going to go back into session. We are back on House Bill 806. Leader Lamberth.
Mr. Chairman, again, I always respect folks that come and testify, especially the criminal defense attorneys. I understand that they are opposed to this bill and totally respect that, but we're going after the worst of the worst here. And believe it or not, I mean, high-level criminals don't always just get caught for high-level offenses. But when you have a combination of 3 more individuals that are all together to try to commit multiple different crimes, we're not talking about guys at a poker night. We're not talking about kids in college, though I would highly recommend, if folks don't want to violate this particular bill if it passes, don't sell weed, don't gamble, don't break the laws of the great state of Tennessee, and you don't even come close to violating this. But this is something, if passed, I think that we would watch very closely. And if there's ever a district attorney out there that tries to abuse this and overutilize it for low-level crimes, it says in here, this is not for those one-off felony or criminal offenses. This is for organized crime. This is a tool to go after the worst of the worst. With that, Mr. Chairman, I stand ready for questions.
Representative Hardaway.
Thank you, Chairman, and thank you, sponsor, for that explanation. When you say one-off, you mean one-off in terms of coming under this bill for charges and conviction, or one-off in terms of committing one of these activities ahead of being charged.
Thank you, Mr. Chairman. Again, it is not the intent of the General Assembly that isolated incidents of felony conduct be prosecuted under this part, but only an interrelated pattern of criminal activity.
All right, thank you.
Representative Gillespie.
Thank you, Mr. Chairman. I call the question.
Okay. Questions called. Any objection? Seeing none, we're now voting to send House Bill 806 on the full criminal. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on. If you wish to be recorded as a no, please see the clerk. Members, we will go to item number 22, House Bill 659 by Representative Martin. You are recognized.
Thank you, Mr. Chairman.
Yes, sir.
This is a bill that was brought to me by a constituent in my district, a young man at East Tennessee State who participated in the Tennessee Intercollegiate State Legislature with other young people this summer. I heard lots of stories of young people who had been assaulted when they were before the age of 18. And the question came is, why didn't people come sooner to report the crime that had been committed to them while they were teenagers? And the answer was that they were worried about negative stigma, and is the reason why they didn't immediately come forward. And so many young victims of sexual assault are unable to understand their experiences, let alone bring the assault to the attention of others. And so what this bill does, it has no physical impact, but it seeks to clarify in current code what is often already interpreted in the courts by saying that it cannot be used in the court, the argument of why a young person took so long to come forward, and so that the matter is being judged on the merits of when the crime happened.
Thank you. We have questions or comments for the sponsor. No, we do not have a guest here to speak.
Yes, and thank you, sponsor. We had discussed this before about several other parts in the code. If we adapted this, we would have to really look at all these other pieces that we'd have to open up and add the same language to make them equal. So that's probably worthy of looking at. And with that in mind, Mr. Chairman, I move this bill to summer study.
As a proper motion. Any objection? Seeing none, we're now voting to send House Bill 659 on to summer study. Those in favor say aye. Aye. Those opposed? No. The ayes prevail. It goes to summer study.
Thank you, Mr. Chairman.
Ladies and gentlemen, we have 5 minutes left in this room before we are to vacate. So we've got 2 bills left to take up. There are many folks that are here, I'm sure, to testify on this bill. So we will start on item number 23, House Bill 120. I will let the sponsor know that once we hit the mark, we have to leave the room. We'll have to continue next week when we come back. Item number 23, House Bill 120. Motion. You are recognized.
Thank you, Mr. Chair and committee. This is probably the shortest bill that I come across this subcommittee this year. It just simply goes to clarify or change the law that was passed last year under the constitutional carry, changing the word handgun to firearms. And why that is so important, there's only 4 states in the entire union that outlaw the carrying of a shotgun. So the example I would give to you is if I met somebody at a gas station parking lot and I wanted to borrow their pistol, they could hand me their pistol and that's completely legal. But if I wanted to borrow their shotgun to go duck hunting, I just committed a crime. And if my truck broke down as I was headed to the duck pond and I wanted to make sure that my gun was not left inside the vehicle, I'm committing a crime. And we're one of only 4 states. The other 3 states are Florida, New York, and New Jersey. So that is what this bill goes to do, Chairman. I stand for any questions. I know there's some folks that might want to end up talking. I don't think we have time.
Thank you. Do we have any questions for the sponsor? Representative Gillespie.
Thank you, Mr. Chairman. To the sponsor, I've got a lot of concerns with this legislation. I mean, where I live, I just cannot fathom someone walking down the street there's no purpose or need whatsoever for someone to be walking down my sidewalk with a shotgun or a rifle. Can you just give me one reason as to why that would be necessary on, say, Poplar Avenue in Memphis, Tennessee?
Absolutely. Thank you, Chairman. The Second Amendment.
Can you elaborate, please? Because I'm still a little confused.
So if you read into that, it says the right to keep and bear arms shall not be infringed.
You're missing half the amendment there, but
So I answered a question. Is there another question?
we're just going to agree to disagree.
Okay.
Representative Johnson.
Thank you, Mr. Chairman. So can you give me an example? What type of, does this allow you to carry virtually any kind of firearm for anyone?
Correct. So it's guns that are legally allowed to be owned in the state of Tennessee would be able to be carried. When you end up looking at the state's definition right now of handgun, when I sat down with Legal Services back in November on this, the state's definition of a handgun is a weapon or a gun that is manufactured to be fired with one hand. If you go to Beretta's website, you go to Smith & Wesson, you go to any of these manufacturers, they show proper shooting form and how to actually shoot a particular gun. All these pistols, you have your primary hand and you have your support hand. Nowhere on there does it say a pistol is manufactured to be fired with one hand, and I couldn't find anywhere on any of the shotguns on there or rifles to where they're manufactured for one hand as well.
So it does allow carrying any firearm anywhere?
That's legal in the state of Tennessee, correct.
Members, if you will, hold your questions, write them down, bring them back with you next week. We're going to roll this bill and all remaining bills on the calendar to next week's calendar. We are out of time, so we will adjourn. I appreciate everyone's patience, and I apologize that we had such a lengthy calendar, but we are adjourned.